Good afternoon, everyone. It's Tuesday, February 25th, and I call the meeting of the State Elections Committee to order, and we do have a quorum in the room. We have two items on the agenda today, and they appear to be relatively straightforward bills. And the first one we're going to take is Senator Westlin's Senate File 1851. If Senator Westlin can make her way to the front. And Senator Westlin, I think the first thing we can take care of is the A1 Author's Amendment.
Yes, give me 1
second.
second.
Get the bill into the form you desire. Everyone has the A1 amendment, I'm assuming, and everyone in favor of the A1 amendment, say aye.
Aye.
All opposed, say nay. The A1 amendment is adopted. Senator Westlin, please name your position as Vice Chair of the Elections Committee and proceed with your presentation.
Thank you, Mr. Chair and members of the committee. I am happy to be here to present Senate File 1851. In 2021, the FBI stated that there had been a large uptick in what they referred to as scam PACs. A scam PAC would be a repeated instance of organizations under feel-good names asking for donations that under the insinuation that those donations will go to a candidate or a political party or an issue, perhaps. In 2022, a scam PAC called Law Enforcement for a Safer America raised $14 million. However, 87% of those donations went to fundraising costs. In 2024, PACs called Patriots for American Leadership and Campaign for a Conservative Majority used a clip of President Trump's voice in a robocall, followed by President Trump needs your emergency support right now. With no time to waste and results coming in by the minute, do your part to help the campaign until the very end by pressing 3 right now to contribute to elect President Trump. Patriots for American Leadership was not affiliated with the Trump campaign and donated only 3% of their 1.4 million donations. The other 97% paid for vague and miscellaneous fundraising costs. While existing law prohibits groups from using campaign funds for personal use, Senate File 1851 expands such protections to include fraudulent misrepresentation and fundraising. The benefit of a specific statute that provides a civil action is that it provides the courts with clarity that someone may actually bring an action for the specific conduct instead of placing a burden on plaintiffs to make an argument that they have standing, or the statute was intended to apply to a particular set of facts. In terms of the bill itself, Subdivision 1 prohibits one from misrepresenting a person, campaign, or organization with the intent to defraud or knowingly participating in such a plan or scheme. Subdivision 2 indicates that a person violating this section is guilty of a gross misdemeanor. This section also lays out civil remedies. The Attorney General, County Attorney, or the injured party may bring forth a civil action to recover damages, together with the costs of investigation and reasonable attorney's fees. In addition to damages, the court may impose a civil penalty up to $1,000 per violation. Section 2 states that Section 1 is enforced as provided in that section instead of through the administrative hearing process. And then the amendment that we adopted basically on line 2.3 changed that to say that the Attorney General, a county attorney, or a party injured by a violation. And then in 2.7 changed the language to say benefits the public, which is a concept located elsewhere in statute. This bill protects Minnesotans who are looking to donate their personal funds, their personal resources to political causes. These scam PACs prey on people's interest in certain political issues and scam them out of their hard-earned money. Senate File 1851 strengthens protections against abusive practices that often unfairly target our seniors and veteran populations. Minnesotans should never be preyed on for wanting to participate in our democracy. And here to testify, Mr. Chair, I do have one person by Zoom, Elizabeth Shimek from the Campaign Legal Center.
Thank you. I think we have Ms. Shimek on video. So, Ms. Shimek, please identify yourself for the record and proceed with your testimony.
Thank you, Chair Carlson and honorable members of the committee for this opportunity to testify in support of Senate File 1851 today. As you mentioned, my name is Elizabeth Shimek, and I'm Senior Legal Counsel for Campaign Finance with Campaign Legal Center. CLC is a nonpartisan, nonprofit organization based in Washington, D.C., and dedicated to protecting and strengthening democracy through law at all levels of government. Senate File 1851 helps to address an under-recognized issue in our campaign finance system today: shady fundraising groups commonly known as scam or sham PACs. Scam PACs are political action committees that claim to raise money for political causes, including to support candidates and political parties, but instead secretly divert almost all of their donors' money back into fundraising or into their own pockets. Scam PACs use many tactics to convince people to donate money. Often, these groups use the name, image, or voice of political candidates in robocalls and email blasts to deceive potential donors into believing that they have contributed to the candidate's campaign or a political party's work. Once they've parted donors from their money, many scam PACs spend lavishly on staff salaries and perks or provide indirect kickbacks to PAC managers or their families by contracting with donors or with vendors, shell companies, where the managers or their families hold a personal financial stake, while spending little, if any, of the funds that were raised to actually support the candidate or cause that they fundraised on. By deceiving and defrauding the public, scam PACs harm the direct donors that give them money, the causes and campaigns that were meant to benefit from the donations, and our democracy by undermining trust in our elections. While scam PACs have been an issue in U.S. politics for more than a decade, the problem has intensified in recent years, prompting the U.S. Department of Justice and many state attorneys general, including in Minnesota, to issue warnings to the public. SF 1851 would help to address this trend. First, by prohibiting the fraudulent misrepresentations that many of these groups rely on to raise funds, and second, by creating civil remedies and criminal penalties that the Minnesota Attorney General, county attorneys, and the people harmed by scam PACs' fraudulent misrepresentations may utilize against these groups and their operators. Thank you for your time and consideration. I'm happy to take any questions.
Thank you for your testimony. Any further comments? We have, we'll open it up to committee questions. Senator Barr.
Thank you, Mr. Chair. Senator Bolden, I've got a couple of questions.
Westlin.
Oh, sorry. You guys
Senator,
don't
we
even
all
say
look
Mayor Color.
alike.
Sorry. My bad.
Senator, put your glasses on.
Hike them up. Maybe take them off. I'm sorry. Senator Westlin. The first one in this is mentioned a couple times in here where you're describing the misrepresentation on behalf of a real potential spurless party candidate. So what I'm not, correct me if I'm not reading it right, but if there's an issue, we've had pro-gun, anti-gun, we've had abortion, anti-abortion. Some of the hotter topics of our time, you'll have groups on both sides, they're just strictly issue groups. Is that covered by any of these in your list of things here?
Mr. Chair.
Senator Bolden. Or Senator Westlin.
I mean, to be clear, I deeply respect Senator Bolden. She is a rock star. But honestly, thank you for the question, Senator Barr. My reading of this is if it says, it refers to committees, funds, or organizations. And so I do think that it goes beyond just a party or a candidate. So I do believe it does impact, say, somebody is purporting to represent a particular gun group that they don't actually represent. I think that would be covered by this language.
Senator Barr, follow up.
Thank you, Mr. Chair. Senator Westlin. So when you get into these issue groups like this, we've seen a lot of times where they'll cover the expenditures in advertising, and then maybe they own a mail house or an advertising firm or something like that. They'll own an outside entity, and they'll funnel large chunks of this money through that entity. Once it's gone to that entity, how do you track past that? I mean, you're not burning it in salary, so it's a justifiable expense, but if you own it, is there some mechanism to draw all those pieces out?
Mr.
Senator
Chair,
Westlin.
Senator Barr, that's a great question, and actually, I'll have Ms. Shimmick talk about this as well, but I believe in her description, she actually said that it could be money that's diverted to vendors. And so if somebody is running the sham pack and they own the mail house that the money is being funneled to, I think that that would be covered by this situation, but I'm happy to phone a friend for further clarification.
Ms. Shimmy.
Mr. Chair, Senator, my understanding is that this bill focuses primarily on the fraudulent misrepresentation when a scam or sham pack is fundraising using someone else's image. The question about how to deal with where the scam or sham pack is funneling money to a different organization where someone is personally benefiting, I think would likely fall under Minnesota's personal use statute. Counsel for the committee may have more knowledge about that. Unfortunately, that's not my area of expertise today.
Thank you for your testimony. Counsel, do you have any comment on that? Good. Committee Counsel Stengel will fill us in.
Mr. Chair and Senator Barr, I think we're starting to tread into judiciary territory on current laws. So I can't weigh in a whole lot. I do think that part of it weighs in on the intent. So is there the intent to defraud? So there are situations where whoever is spending the money can appropriately pay vendors for what they're doing. But if the intent is to defraud and they say, we're collecting money to give to this candidate, and they have no intention of giving the money to the candidate, and instead they funnel it through their own company and keep it for their own profits, then that's the intent to defraud. If instead they say, we are going to give it to this candidate to help them run their campaign, and they give it, run it through their own company to pay for in-kind contributions, that's probably not intent to defraud, and that seems appropriate. So it seems like it'd probably be very fact-specific on whether there's intent to defraud and how the money is used.
So based on that, Mr. Chair and Senator Barr,
Senator
I think that makes sense to me as well, is that if they take the funds and they run it through their mail house and the mail house actually does something for the benefit of the candidate, then at that point they haven't defrauded. I mean, they're doing what they said they were going to do. But if they have a mail operation and that and again, the intent is we're getting all this money, we're going to maybe do a de minimis amount that we're going to contribute, but the rest of it we're going to shuffle around and either send it to my personal business or something else. I do think that would be covered, but I appreciate the question.
Senator Barr, follow up.
So one quick follow-up then. So if you run it through an outside vendor, you collect the money on behalf of an issue, and you run it, most of the money, say 90% of it goes to the mail house to raise awareness, and you own the mail house. And how would you determine, I guess this would be getting into where the campaign finance problem, how far down that trail could you go to say maybe you're paying yourself an exorbitant amount in salary, you're still sending mailings, but we don't have authority to go into a private business and say, how are you conducting your business? How are you paying your employees? How much are you keeping in for compensation for yourself? That seems like just one line too far. I like where you're at. I like where you're going, because we all see scams of all the time. I was just kind of curious if there was a way to have these vendors, but I think we're probably going to be just a bridge too far to get to that. So thank you.
And
Thank
Mr.
you,
Chair,
Senator Barr.
I think
Senator Westlin.
So I think there's a potentially separate or different issue that you may be getting to, which is the organization is raising funds, let's say for an issue, legitimate, for this issue. They're hiring vendors that they have a pecuniary interest in, and they're benefiting from it, but they are actually advocating for the issue. In this case, they haven't defrauded it, but the other issue is, again, a different issue is, as you're raising money, what kind of disclosures do you have to make about where you're spending your money? And is there transparency in that? And I do think I agree with you, that's an issue. I'm not sure that that's necessarily what this one is getting to. This really is, we are just raising money. We're implying or insinuating we're raising money for a party or a person. We may or may not actually donate money to that party or that person in some small, tiny amount, but the rest of it we're pocketing in one way or the other.
Senator Lucero had a question.
Thank you, Mr. Chair. And my question is either to the senator or to the testifier. So when I was listening to the opening remarks of the testifier, one of the examples was a group that was fundraising ostensibly in favor of law enforcement, I think was the example given. And I've heard of similar cases where somebody has a health condition and they stand up like a GoFundMe account or something like that. And then I hear subsequent media reports of them being prosecuted by something. I don't know if it must be criminal or if they were being sued civilly or whatever. But my question is, under the bill that's being proposed, it's in the capacity of an election or a PAC or super PAC or fraud PAC. But is there anything under current law, criminal law, that might cover this exact same behavior, such as the GoFundMe misrepresentation?
Senator Westlin.
Mr. Chair, Senator Lucero, so this actually creates a private right of action, which does not currently exist. So this does carve out a very specific situation that is not necessarily covered by existing law. And this allows individuals to either pursue an action on their own, and the county attorney or the attorney general can also pursue civil remedies. So I think that I'm not sure if your question is whether this is like strictly just limited to politics. I don't think it is necessarily just limited to politics, but it is about sort of the misrepresentation in a fundraising capacity. But this specifically carves out that private right of action.
Follow-up, Senator Lucero.
Thank you, Mr. Chair, and I appreciate that. And I won't ask more questions, but just a comment to clarify where my mind is anyway, and that is I tried to write down some terms here in a GoFundMe or the testifier's scam law enforcement. I wrote down fraud, misrepresent, swindle, deceit, theft, and scam. And I don't know if under current law those are criminal offenses or some variation of them. And could the very act that was described by the testifier, is it already covered? But then, again, we just heard Mr. Chair, Senator Westlin say that the main distinction between whatever may exist in the tool chest to go after these scammers, this is allowing for a private right of action. And that's what I was seeking to clarify. What's new? Because I hear these stories that people had gone after for misrepresentation. Let me be clear, Mr. Chair. I am on the front lines of wanting to go after these people that misrepresent and they take the hard-earned money from people that make contributions under false pretenses. That is the lowest of the low. When people think they're supporting cancer or law enforcement or a political candidate, but they're trying to abuse the system and the goodwill of people, that definitely is something we need to continue to address. So thank you, Mr. Chair.
Mr. Chair, just to add to that too, so the other part of this is this bill does actually make it a gross misdemeanor to do this. And currently, under current law, theft and fraud crimes do not necessarily cover this specific situation. So this also does carve out a specific gross misdemeanor crime that can be prosecuted, but the other piece is the civil piece.
Senator Limmer.
Thank you. Senator Westlin, you may have answered my question just in your last statement. My big question was, why doesn't theft by fraud in statute already cover this crime?
Mr.
Senator
Chair
Westlin.
and Senator Limmer, my understanding is that the current definitions do not cover this specific situation necessarily. The current theft and fraud crime does not get to the situation where someone's fundraising ostensibly for a candidate, for a party. They're maybe donating some of the money, but they're keeping most of it themselves. It is not currently covered. And there certainly was no private right of action associated with the more general, case law and so on.
Mr. Chair,
Senator Limmer.
my other questions are probably more for judiciary, but I can ask a little bit more. Usually if there's a theft, it's bifurcated by dollar amount in statute, separating misdemeanor, gross misdemeanor, and felony by the dollar amount that was taken. Your bill only recognizes the act itself as a gross misdemeanor, but would you be amenable to a future amendment in another committee that would recognize the felony dollar amount? Some of these dollar amounts that from these type of organizations are in tens of thousands, maybe hundreds of thousands of dollars, and to think that they'd find this, someone would be guilty of this would only get a gross misdemeanor, I would tend to think might be inadequate for the risk that they're going to take.
Mr. Chair.
Senator Westlin.
Senator Limmer, I'm certainly willing to continue to have that conversation. The one thing I will note, though, too, in addition to the criminal penalty, is that it does provide for civil penalties up to $1,000 for each violation. And so that civil penalty could actually be quite significant. But I'm happy to have some additional conversations with you about that penalty fee, for the criminal piece of it.
Mr. Chairman, Senator
Senator Limmer.
Westlin, you're making reference to line 2.9. The word cumulative is what would add on to the civil penalty. While we're talking about civil action on lines 2.4, an individual may make a civil action, but it says pursuant to section 8.31, which is the Attorney General chapter. So could you explain how an individual can bring a private action via 8.31? Is that meaning that the Attorney General becomes their attorney? I'm a little rusty on that. Could you help me out with that?
So, Mr. Chair, Senator Limmer, that's a good question. So I think that with the civil right of action, this permits the Attorney General's office to bring a claim that benefits the public. And so one of the things that this bill does is that actually you don't have to, as a plaintiff, prove that your action would benefit the public. We're already saying that what they're doing is incorrect and so on. And so this provides that the Attorney General, the county attorney, or the party, any three of those, could bring the civil action. I'm not sure if that gets directly to your question, but I believe 8.31 is the authority for the Attorney General to bring the action under the Attorney General statute.
Mr. Chair, I'm wondering if council could give us clarification on the private right of action via Chapter 8.31.
Mr. Chair and Senator Limmer and Senator Westlin, I cannot answer that question, but I can certainly ask Ms. Primo to look into it and advise the Judiciary Committee when the bill comes to them.
I'll
Mr.
hold
Chair.
the question until the next stop, Mr.
Yeah,
Chair.
Mr. Chair and Senator Limmer, I was just going to say this might be, I will certainly do what I can between now and then to try and get answers to some of those questions, but I think this does sort of veer into the jurisdiction of our beloved Judiciary Committee, so.
Other questions? Well, I have a couple of questions now. And I've I did, for just a brief moment, confer with counsel. This has a reach outside of Minnesota, but the crime would be a Minnesota crime, from what I understand. And the, let's say, the remedy would be strictly within Minnesota. Am I correct on that?
Mr. Chair, I think we're going to have to bring this up in judiciary because I think we're sort of veering into criminal penalties. But if you commit a crime in Minnesota, you are subject to Minnesota jurisdiction, and you are subject to if you're doing business in Minnesota, you're subject to the laws of Minnesota. So I would assume that if someone is convicted of this crime, this gross misdemeanor in Minnesota, they would be subject to the laws here. And the civil penalties as well. I mean, the suits would be brought here, but there would have to be a nexus between, it would have to be someone in Minnesota has donated to one of these sham PACs, and the sham PACs have to be operating and soliciting funds in Minnesota. There has to be a nexus with our state.
Okay. All right. And I guess what I want to do is I want to say why I signed on as a co-sponsor. This has been something that has been at the top of my mind for quite some time, but I think my exposure to it has been national, and it's been organizations that use someone else's name to and their own name as a PAC, and they try to get donations so that they can support another issue or candidate that might be a national candidate. And so, and I have several questions, but I think we can leave some of them for the Judiciary Committee. But I'm wondering if there are very many of these instances that are happening within Minnesota that Minnesota can take action with. Do you see this as a broad issue for Minnesotans? Senator Westlin.
Mr. Chair, I think that as our testifier mentioned as well, this is a problem that's been increasing considerably over time. And I will just say that the FEC federally is also taking actions against misleading and fraudulent PACs because they have also found this to be an increasing action. So this is an opportunity for us to do something within the state of Minnesota for people who may operate in our state and be taking advantage of our citizens. My understanding is the Federal Elections Commission is doing the same thing on the federal level.
And if, I'm not sure who actually mentioned it, that they might have an agreement with someone. So if I, as a candidate, have an agreement with one of these scam fundraisers that I'll take somewhere between 1% and 90% of what they raise under my name, what becomes a scam? Do we have a threshold that when they're a scammer and when they're a legitimate fundraiser that has an agreement with me as a candidate or with another PAC as an issue PAC?
Mr. Chair, I'm not sure I know the answer to that question, but I'm going to assume that there are other campaign finance laws and rules that would be in place in terms of contributions from PACs to candidates that I think would apply in the situation. This specifically is going to situations where someone is raising money allegedly for a party or a candidate, potentially an issue, that they have absolutely no intention of supporting. Like, the intention is for them to raise money and to enrich themselves. It is an intention to defraud people. So that is what is unique about this particular situation. And again, when we go out from here, there may be any number of other permutations of problems with campaign finance laws, but I just want to narrow back in that very specifically that there's a sham PAC, they're raising a ton of money, they are spending that money on themselves and on fundraising expenses, and they are contributing very little, if anything, to the actual candidate or party that they are insinuating that they are raising funds for.
And another related question is that there are these organizations, or let's say intermediary people, who gather your credit card and information so that you can go right to them and donate to another organization, another PAC, or a candidate. But and they're supposedly a trusted handler of the money, But if you go to the PAC's actual report, and this is what I've been doing, is going to the organization called Open Secrets to look at the budget that that PAC has. And I find out that it's just as you say, that the leaders of that PAC are paying themselves gross amounts of money, and they pay for other things that you would not say that most fundraisers are exposed to, but a very little to the eventual person named in the PAC or the candidate that might be the name they use when they call you up and try to convince you to contribute.
Mr. Chair, that is also a problem, but that is not the problem we're getting to here. And that is really a problem of an organization that is taking exorbitant fees for the services that they provide. But that is not really the situation here. The situation here is somebody is literally raising money with the intent to defraud people, claiming that they are supporting a candidate or a party, and they are not supporting the candidate or the party.
Okay. And we have some more questions here. Senator Grant.
Thank you, Mr. Chair. Senator Westlin, I haven't seen, or we haven't heard the position from campaign finance. Campaign finance is involved in this. What impact would it have if any one or a handful of these cases roll through the campaign finance? Is there a financial impact, administrative impact, and do we need a fiscal note from campaign finance?
Mr. Sigurdson is at the microphone. Please identify yourself for the record and continue with your answer.
Mr. Chair, Jeff Sigurdson with the Campaign Finance Board. Sir Cran, this would actually be outside of the jurisdiction of the board. This particular section of 211B is with the Office of Administrative Hearings, or the way it's set up, it goes directly to the Attorney General's office. But we only have limited authority over certain parts of Chapter 211B, and this is not one of those parts.
Okay. Excellent. Thank you.
Thank you. Senator Lucero.
Thank you, Mr. Chair. The further dialogue made me think of other questions. So as I was reading the language here, to the intent, as I understand it, is to raise money by misrepresenting or defrauding. But and I look at the details of the language. I'm specifically looking at line 1.10 and 1.15, and on both of those, the verbiage is for or on behalf of. And so, what if there's the inverse scenario? It's a sham organization that is fundraising against something. So against Governor Walz or against Senator Lucero. But everything else is the same, all else being equal, but it's not for, but they're taking the money, they're doing everything else that's in here, it's against a candidate. Would such a scenario be covered by your current language?
Mr. Chair,
Westlin.
in my opinion, yes. I mean, I think that's an overly literal. I think that, again, the intent is you're raising funds. Arguably, if you are opposed to one candidate, you may be in support of the other one, generally speaking. I believe that this bill covers that situation.
Follow up, Mr. Chair.
Follow up?
Okay, thank you. And to be clear, there are organizations out there that they're for themselves. And in order to be for themselves, they're against something else. And when I look at the language, I don't think it would be interpreted that way if it ever were to come to court under a private right of action or whatever, because it says they are speaking, writing, or otherwise acting for or on behalf of a real, potential, spurious, or non-existent candidate. But again, there are people or organizations that can raise by using the emotional connection, by being against a movement, an action, a personality, a topic, et cetera. So just something out there for your consideration.
And Mr. Chair and Senator
Senator
Lucero, I think just to sort of circle back, it's the intent to defraud that we're getting to here, that somebody is raising money with the intent to defraud, that they have no intention of either supporting or being against any candidate, party, anything else. They are literally raising money to enrich themselves, and I think that covers that situation.
Mr. Chair, I'd like to make an oral amendment
Lucero.
for us to consider. So I understand the intent. I just don't think the language necessarily aligns with the intent. So the oral amendment here would be in two places. In those two places I just referenced, so 1.10, it'd be to add the word or against in between behalf, or after the word behalf on each of those two lines. So acting for or on behalf or against, and then perhaps delete the word of. Then it'd be any real, et cetera, et cetera. So now it's for or against.
Could we have Ms. Stengel read the change as it would be with the Lucero amendment approved in it?
Mr. Chair and members, on page 1, line 10, after of, insert against, so it would read for or on behalf of or against any real. And on page 1, line 15, after of, insert or against.
Okay. Any questions on the amendment?
Mr. Chair,
Senator Westlin.
I would just ask members to vote against this. I do not like doing things on the fly. We have consulted with both counsel from Judiciary and from Elections in drafting the bill. Before we make any sort of changes to anything, I would like to have the opportunity to talk to especially Judiciary counsel, just to make sure that we aren't creating an unnecessary situation or making an amendment that's not necessary. I just don't like doing things on the fly.
Mr. Chair?
Senator Lucero.
Quick question. What is the path for this?
Judiciary.
Judiciary.
Okay, so Mr. Chair, then if their concern is judiciary and wanting to speak to Judiciary Council, and the next stop of this bill is judiciary, then I would encourage members to vote in favor of. I'm disappointed that there's the bill authors against this. So because the bill authors against this, I was hoping it would be friendly. Then I guess I'll ask for a roll call.
Roll call requested. Roll call granted. Any other questions about this amendment? And the author has suggested a no vote on it. The clerk will take the roll.
Senator Carlson.
No.
Senator Coran.
Yes.
Senator Westlin.
No.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swazinski.
Nope.
Senator Limmer.
Yes.
Senator Lucero.
Yes.
Senator Marty. Senator Matthews.
Yes.
Senator Port.
No.
There being 5 ayes and 6 nay votes on the Lucero motion, it is not adopted. And I think we will have another chance with this with multiple members of the committee here in the Judiciary Committee. So, and we have some more questions. Senator Matthews. Okay, you're passing. Senator Port.
Thank you, Mr. Chair. Thank you, Senator Westlin, for bringing this. I think more transparency and accountability in the money space of politics is really critical. I think this tackles a specific, very narrow but growing concern we have. I appreciate you bringing this forward. I think some of the other concerns folks raised about how money is spent, who is giving the money, and things like that, they can sign on to my original source bill, and we'll have that conversation then. But I appreciate you bringing this bill, and Mr. Chair, I would move that Senate File 1851 as amended be recommended to pass and referred to Judiciary.
Thank you, Senator Port. We do not have any other people on the list here for questions. So all in favor, say aye.
Aye.
All opposed, say nay. No. The motion is passed, and you're on your way to Judiciary.
Awesome.
I want to say one concluding remark on this. If someone wants to know and maybe wants to get the hairs on their neck standing up, just go to HBO and pull up the HBO special called Telemarketers. Because if you watch that, you'll come away with a very specific issue with telemarketers who are gathering funds with scam in mind, because they take most of the money themselves. And it's a documentary that was actually made by one of the telemarketers that was involved in the scams. So just telemarketers. Thank you. Next bill we have is from Senator Draheim. And Senator Draheim has number 1259. And Senator Draheim, just identify yourself so we can get to know your voice and proceed with your presentation. But I understand we do have an A1 author's amendment that you would like to have considered. And Senator Draheim, I move the A1 author's amendment. All in favor say aye. Aye. All opposed say nay. The motion passes, and A1 is included in the bill. So Senator Draheim.
Thank you, Chair. Thanks for hearing Senate File 1259, and thank you, members. You know, like Senator Westlin's bill, I think a lot of us that pay attention to politics, we get frustrated with some of the activities that go on. And, you know, for me, part of the reason I wanted to do something on this was twofold. One, I think our requirements are a little outdated. And there's a lot of chatter, and a lot of my constituents complain about all the money in politics. And they're saddened to hear that it isn't at the state level as much as it is the federal level, where there are politicians that are benefiting from their position. And I think the best way to fight that is through transparency. And I'm all in favor of transparency. This is my attempt to make the system better for us and just to be more transparent. So after the A1 is adopted, thank you, members, for that. What it just says, the bill requires reporting the sale or purchase of individual stocks if the elected official's shares of the stock is worth more than $10,000. So if you look through the current chapter 10E.09 subdivision 5, you know, we're required obviously to our name, if we're in a business, report any real property if it's over $2,500. Any partnership that has a value that exceeds $2,500. We have to report any horse racing. If we're a professional business, if we have a business with more than 25% ownership or constant $250 a month income. Independent contractor, that in the last 12 months we report 2,500, and then we get into the security under Section 8, which is at $10,000. And so what we're just adding is that line 2.4 to 2.6. We just want some record keeping on when you bought the stock. So we know when and how much. So that's pretty much it, Chair. Pretty straightforward. You know, I personally think the value of property could go up throughout this section of law, but that's not what I'm trying to get at today. So just transparency.
Mm-hmm. Thank you, Senator Draheim. Any questions from the committee? Senator Westlin.
Thank you for bringing this bill forward. I did have one question. It specifically focuses on stocks. And I think more and more today, especially people who work in the corporate environment may have stock options versus actually stock. And I'm curious to know if you considered sort of expanding this beyond just individual stocks to sort of other holdings that, for transparency's sake, might be of interest to report on something like this.
Senator Draheim.
Thank you, Chair, and thank you, Senator, for the question. We have discussed it, and, you know, I didn't really want to handicap, some people get stock options for their jobs. You know, if you work for a large corporation, and I don't think it really benefits you immediately. And what I was trying to get at, I'm gonna pick on Senator Marty a little bit. So let's say Senator Marty knew that one of his corporations that he has lots of stock in came in and had a private meeting, because, you know, he chairs the Finance Committee, pretty important committee, and they told him that they would go out of business if they didn't get whatever bill passed. And he had inside information that the public didn't know. And of course, Senator Marty would never do this, but if he would benefit from that, I think it's important. So the next day he dumps, or that day, he dumps all of his stock in XYZ Corporation, which is worth millions. And I think the public has the right to know that, Senator Marty, if you had stock options, there's usually a process to sell and to purchase stock options that take time. And what I'm trying to get at is kind of the inside information angle of this. I think we already have reporting on what stocks we own, but we really don't know the timing of it. So on the other hand, if Senator Marty is a wise investor and he sees a trend coming and buys stock and does well on it, but it doesn't correlate with his business here at the Senate, that's perfectly fine. And the only way to really tell that is to look at when the stocks were purchased or sold. You know, so that's what I was trying to get at. And I didn't think options were as clear cut, but I'm always willing to explore that and have a longer discussion if anybody has a different opinion. And we talked about mutual funds and a bunch of other products that are out there, annuities. But that's kind of harder to have inside information on. So that's kind of what I was trying to get at. And I wish I had a magic wand and I could do this on the federal side too, but we can't. Not yet, no.
Other questions? Senator Lucero.
Thank you, Mr. Chair. And my question might be for Senator Draheim or perhaps the Campaign Finance Board. As I'm looking at this, obviously we're talking stocks, and I looked back earlier in the bill and there is no definition section, which was perhaps the definition section is earlier, so it's not to be printed here. But my question is, can you refresh my memory? What is the definition of a stock under current law? And is there a distinction between stock and what's under Draheim just referenced which is a mutual fund? And so is there an expectation that if we're holding the mutual fund and or if we sell a mutual fund, are we required to list potentially 700 individual stocks that make up that mutual fund?
Senator Draheim.
I think the Campaign Finance Board would be better at able to answer
Mr.
that,
Sigurdsson.
Chair.
Mr. Chairman, Senator, the definition of securities is I think what would be focusing on. Chapter 10A does define securities to mean stocks, shares, bonds, warrants, options, pledge, note, mortgage, annuity, debenture, lease, or commercial paper in any corporation, partnership, trust, or other association. And then the second part of that definition says securities do not include savings accounts, certificates of deposit, money market certificates, treasury bills, treasury bonds, treasury notes, shares in a mutual fund, shares in an exchange traded fund, or an underlying holding owned by an annuity or in a defined benefit pension plan. So to your specific question, No, individual stocks within a mutual fund would not be under the definition of security and would not be disclosed.
Senator Lucero.
Thank you, Mr. Chair. So a follow-up, just trying to think of the more obscure real-life examples. And so another one popped into my head would be a variable life insurance policy will have its investment in potentially stocks and potentially a mutual fund. In the definition that we just heard, that a security would not include a mutual fund. So what if a person has a life insurance policy that perhaps they exercised or they terminated, that was a universal variable life, and the investments were individual stocks now, not individual securities, is the expectation then that the stocks that make up that universal variable life insurance would be reported?
Mr. Chair, Senator Lucero,
Mr.
I don't
Sigurds.
think so unless the life insurance policy allowed you to direct the purchase and sale of stocks within the life insurance policy. That typically is not the case. At least that's my understanding. That's why the mutual funds are excluded, because you don't have the ability to direct the mutual fund on what stocks to purchase or sell, and so with that same logic, it would not be included.
Follow up, Mr. Chair. Thank you.
Senator Lucero.
Okay, so then within a universal variable life, and again, we in the weeds here, but in the weeds matters because it's going to be those one-off exceptions. In a universal variable life product, one can decide the allocation of the funds. And if the allocation options did include an individual stock, I just want to be clear, if the allocation did allow for the selection of individual stocks within the life insurance policy, would those be in scope for the current language?
Mr. Chair, Senator Lucero,
Mr. Sigurds.
I believe the answer then would be yes. If you are regardless of the method in which you're controlling the purchase and sale of stocks, if you have the right to sell and purchase stocks through that mechanism, through that vehicle, then I believe it would in fact be a security that you would need to list.
Thank you, Mr. Chair.
Thank you. Other questions? Where is this going? Okay. No other questions?
Mr. Chair, can I clarify my answer?
Yeah.
It would be the
Mr. Sigurds.
stocks within that insurance policy that you would list, not the insurance policy.
Okay. Thank you, Senator Draheim, for this bill. I think it looks like it has a lot of interest here in the committee. So what we're going to do is this one is going to be held for, going to be laid over for possible inclusion. So we thank you for bringing the bill here.
Thank you, Chair and committee, and everybody. I'm willing to work on it if people have ideas or if we need to tighten the language. So thank you.
Personally, I'd like you to consider that the stock options, because they are something that you can be invested in and then affect the value of them. It might be immediate, it might be 10 years from now, but they still are a valuable asset.
More than willing to add it as we
Thank
move
you.
forward. Thank you, Chair.
So that concludes the business for today. So the meeting is adjourned.